Question. Bruno still had several years to serve on his sentence when he was conditionally pardoned by the President. Among the conditions imposed was that he would not again violate any of the penal laws of the Philippines. Bruno accepted all the conditions and was released. Shortly thereafter, Bruno was charged with 2 counts of estafa. He was then incarcerated to serve the expired portion of his sentence following the revocation of the President of the pardon. Bruno's family filed a petition for habeas corpus, alleging that it was error to have him recommitted as the charges were false. In fact, half of them were already dismissed. Resolve the petition with reason. Answer. The petition should not be given due course. The grant of pardon and the determination of the terms and conditions of a conditional pardon are purely executive acts, which are not subject to judicial scrutiny. The acceptance thereof by the convict or prisoner carried with it the authority or power of the executive to determine whether a condition or conditions of the pardon has or have been violated. Where the President opts to revoke the conditional pardon given, no judicial pronouncement of guilt of a subsequent crime is necessary, much less conviction therefore by final judgment of a court, in order that a convict may be recommended for the violation of his conditional pardon. The determination of the occurrence of a breach of a condition of a pardon and the proper consequences of such breach is a purely executive act, not subject to judicial scrutiny. It is under Torres v. Gonzalez, GR number 76872. Question. St., a regional trial court judge who falsified his certificate of service, was found liable by the Supreme Court for serious misconduct and inefficiency, and meted the penalty of suspension from office for 6 months. Subsequently, St. filed a petition for executive clemency with the office of the President. The Executive Secretary, acting on said petition, issued a resolution granting St. executive clemency. Is the grant of executive clemency valid? Why or why not? 2008 Bar. A. The grant of executive clemency is not valid. First, in this case, the power of executive clemency cannot be delegated, for it was not signed by the President himself, but by the Executive Secretary. And second, the power of executive clemency cannot extend to administrative cases in the judiciary, because it will violate the principle of separation of powers and impair the power of the Supreme Court under Section 6, Article 8 of the Constitution of administrative supervision over all courts. Forms of executive clemency. Question. The first paragraph of Section 19 of Article 7 of the Constitution, providing for the pardoning power of the President, mentions reprieve, commutation, and pardon. Please define the 3 of them and differentiate one from the others. Answer. The terms were defined and distinguished from one another in People v. Vera, 65 Phil 56 111 until 112 as follows. A. Reprieve is a postponement of the execution of a sentence to a day certain. Commutation is a remission of a part of the punishment, a substitution of less penalty for the one originally imposed. C. A pardon, on the other hand, is an act of grace, proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed from the punishment the law inflicts for a crime he has committed. Diplomatic power. Question. Can the House of Representatives take active part in the conduct of foreign relations, particularly in entering into treaties and international agreements? Explain. Answer. No, the House of Representatives cannot take active part in the conduct of foreign relations, particularly in entering into treaties and international agreements, as held in United States v. Curtis Wright Export Corporation, 299 U.S. 304. The President alone is the representative of the nation in the conduct of foreign affairs. Although the Senate has the power to concur in treaties, the President alone negotiates treaties, and Congress is powerless to intrude into this. However, if the matter involves a treaty or an executive agreement, the House of Representatives may pass a resolution expressing its views on the matter. Q. What are the restrictions prescribed by the Constitution on the power of the President to contract or guarantee foreign loans on behalf of the Republic of the Philippines? Explain. A. Under Section 20, Article 7 of the Constitution, the power of the President to contract or guarantee loans on behalf of the Republic of the Philippines is subject to the prior concurrence of the Monetary Board and subject to such limitations as may be prescribed by law. Q. The Philippine government is negotiating a new security treaty with the United States which could involve engagement in joint military operations of the two countries' armed forces. A loose organization of Filipinos, the Kabataan at Matatandang Makabansa, KMM, wrote the Department of Foreign Affairs, DFA, and the Department of National Defense, DND, demanding disclosure of the details of the negotiations, as well as copies of the minutes of the meetings. The DFA and the DND refused, contending that premature disclosure of the offers and counteroffers between the parties could jeopardize ongoing negotiations with another country. KMM filed suit to compel disclosure of the negotiation details and be granted access to the records of the meetings, invoking the constitutional right of the people to information on matters of public concern. Decide with reasons. Answer. The petition of KMM must be denied. Diplomatic negotiations are privileged in order to encourage a frank exchange of exploratory ideas between the parties by shielding the negotiations from the public view. Akbayan Citizens Action Party versus Aquino, 558 Squa 468. B. Will your answer be the same if the information sought by KMM pertains to contract entered into by the government in its proprietary or commercial capacity? Why or why not? Answer. KMM is entitled to have access to information pertaining to government contracts entered into by the government in the exercise of its proprietary or commercial capacity. The right to information under the Constitution does not exclude contracts of public interest and not privileged. Q. What are the limitations, restrictions provided by the Constitution on the power of Congress to authorize the President to fix tariff rates, import and export quotas, tonnage and wharfage dues? Explain. Answer. According to Section 28, Number 2 of Article 6 of the Constitution, Congress may, by law, authorize the President to fix within specified limits and subject to such limitations and restrictions it may impose tariff rates, import and export quotas, tonnage and wharfage, dues, and other duties, or imposed within the framework of the National Development Program of the government. Q. Distinguish between pocket veto and item veto. Answer. A pocket veto is when the President is considered to have rejected a bill submitted to him for his approval when Congress adjourns during the period given to the President to approve or reject a bill. On the other hand, an item veto or partial veto is the power of a President to nullify or cancel specific provisions of a bill, usually a budget appropriations bill, without vetoing the entire legislative package. Q. Andres Ang was born of a Chinese father and a Filipino mother in Sorsogon on January 20, 1973. In 1988, his father was naturalized as a Filipino citizen. On May 11, 1999, Andres Ang was elected representative of the 1st District of Sorsogon. Juan Bonto, who received the second highest number of votes, filed a petition for the quorum against Ang. The petition was filed with the House of Representatives Electoral Tribunal. Bonto contends that Ang is not a natural-born citizen of the Philippines and therefore is disqualified to be a member of the House. The House of Representatives Electoral Tribunal, or HRET, ruled in favor of Ang. Bonto filed a petition for certiorari in the Supreme Court. The following issues were raised: whether the case is justifiable, considering that Article 6, Section 17 of the Constitution declares the HRET to be the sole judge of all contests, relating to the election returns and disqualification of members of the House of Representatives. How should this case be decided? Answer. The case is justiciable, as stated in Lazarin versus House of Electoral Tribunal, 1968, Squat 391. Since judicial power includes the duty to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government, the Supreme Court has the power to review the decisions of the House of Representatives Electoral Tribunal in case of grave abuse of discretion on its part. Q. What is the difference, if any, between the scope of judicial power under the 1987 Constitution on one hand and 1935 and 1973 Constitution on the other? Answer. The scope of judicial power under the 1987 Constitution is broader than its scope under the 1937 and 1973 Constitutions because of the second paragraph of Section 1, Article 8 of the 1987 Constitution, which states that it includes the duty to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government, as held in Marcos versus Manglapus. This provision limits resorts to the political question doctrine and broadens the scope of juridical inquiry into areas which the court under 1937 and 1973 Constitution would normally have left to the political departments to decide. Alternative answer. Under the 1935 and 1973 Constitutions, there was no provision defining the scope of judicial power as vested in the judiciary, while these constitutions both provided for vesture of judicial power in one Supreme Court and in such inferior courts as may be established by law. They were silent as to the scope of such power. The 1987 Constitution, on the other hand, rewrote the provisions on the vesture of judicial powers, originally appearing in the 1935 and 1973 Constitutions, as follows. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. The second paragraph of the cited provisions was not found in the 1935 and 1973 Constitution. It contains a new definition of judicial power, particularly the scope thereof. The first portion thereof represents the traditional concept of judicial power, involving the settlement of conflicting rights as by law, which presumably was implicit in the 1935 and 1973 Constitutions. The second portion of the definition represents a broadening of the scope of the judicial power, or, in the language of the Supreme Court, conferment of expanded jurisdiction of the judiciary, to enable the courts to review the exercise of discretion by the political departments of government. This new prerogative of the judiciary, as now recognized under the 1987 Constitution, was not constitutionally permissible under the 1935 and 1973 charters. Q. S.T.O. was elected congressman. Before the end of his first year in office, he inflicted physical injuries on a colleague, A.T. In the course of heated debate, charges were filed in court against him as well as the House of Ethics Committee. Later, the House of Representatives, dividing along party lines, voted to expel him. Claiming that his expulsion was railroaded and tainted by bribery, he filed a petition seeking a declaratory of the Supreme Court that the House gravely abused its discretion and violated the Constitution. He prayed that his expulsion be annulled and that he should be restored by the Speaker to his position as congressman. Is SDO petition before the Supreme Court justiciable? Answer. While under Section 1, Article 8 of the 1987 Constitution, the Supreme Court may inquire whether or not the decision to expel SDO is tainted with grave abuse of discretion amounting to lack or excess of jurisdiction. the petition should be dismissed. In Alejandro versus Quezon, the Supreme Court held that it could not compel the state to reinstate a senator who assaulted another senator and was suspended for disorderly behavior, because it could not compel a separate and equal department to take any particular action. In Osmeña versus Pendatun, it was held that the Supreme Court could not interfere with the suspension of a congressman for disorderly behavior, because the House of Representatives is the judge of what constitutes disorderly behavior. The assault of a fellow senator constitutes disorderly behavior. Q. The President alone, without the concurrence of the Senate, abrogated a treaty. Assume that the other country party to the treaty is agreeable to the abrogation provided it complies with the Philippine Constitution. If a case involving the validity of treaty abrogation is brought to the Supreme Court, how should it be resolved? A. The Supreme Court should dismiss the case. The jurisdiction of the Supreme Court over a treaty is only with respect to questions of its constitutionality or validity. In other words, the question should involve the constitutionality of a treaty or its validity in relation to a statute. It does not pertain to the termination of a treaty. The authority of the Senate over treaties is limited to concurrence, Article 8, Section 21 of the 1987 Constitution. There being no express constitutional provision regulating the termination of treaties, it is presumed that the power of the President over treaty agreements and over foreign relations include the authority to abrogate treaties. The termination of the treaty by the President without concurrence of the Senate is not subject to constitutional attack, there being no Senate authority to that effect. The Philippines is a party to the Vienna Convention on the Law of Treaties. Hence, the said convention, this becoming part of the Philippine law, governs the act of the President in terminating the treaty. Article 54 of this convention provides that a treaty may be terminated at any time by consent of all parties. Apparently, the treaty in question is a bilateral treaty in which the other state is agreeable to its termination. Article 67 of the Constitution of the Convention adds the formal requirement that the termination must be in an instrument communicated to the other parties, signed by the head of state or government or by the Minister of Foreign Affairs. Q. Mr. Yellow and Mr. Orange were the leading candidates in the vice presidential elections. After election, Yellow emerged as the winner by a slim margin of 100,000 votes. Undaunted, Orange filed a protest with the Presidential Electoral Tribunal, PET. After due consideration of the facts and the issues, the PET ruled that Orange was the real winner of the election and ordered his immediate proclamation. Aggrieved, Yellow filed with the Supreme Court a petition for certiorari challenging the decision of the PET, alleging grave abuse of discretion. Does the Supreme Court have jurisdiction? Explain. The Supreme Court has no jurisdiction over the petition. The Presidential Electoral Tribunal is not simply an agency to which the members of the Senate Court were assigned. It is not separate from the Supreme Court. Macalintal versus President Tribunal Electoral Tribunal 631 SQA 239. Would the answer in A be the same if Yellow and Orange were contending for a senatorial slot and it was the Senate Electoral Tribunal who issued the challenging ruling? The Supreme Court would have jurisdiction if it were the Senate Electoral Tribunal who issued the challenge ruling. The Supreme Court can review its decision if it acted with grave abuse or discretion. What is the composition of the PET? The Presidential Electoral Tribunal is composed of the Chief Justice and the Associate Justices of the Supreme Court in Bank. And what is judicial power? Explain briefly. Judicial power, Section 1, Number 1 of Article 8, is the authority to settle justifiable controversies or dispute involving rights that are enforceable and demandable before the courts of justice, or the redress of wrong for violation of such right, Lopez versus Rojas. It includes the duty of the courts to settle actual controversies, including rights which are legally demandable and enforceable, to the and to determine whether or not there has a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. In keeping with the modern age of instant and incessant information and transformation, Congress passed Cybercrime Prevention Act to regulate access and use of the amenities of the cyberspace. While ostensibly the law is intended to protect the interests of society, some if its provision were also seen as impermissibly invading and impairing the widely cherished liberties of the people, particularly the freedom of expression. Before the law could even be implemented, petitions were filed in the Supreme Court questioning said provisions by people who felt threatened for themselves as well as for the benefit of others who may be similarly affected but not minded enough to challenge the law. The Solicitor General countered that there is no basis for the exercise of the power of judicial review since there has not yet been no violation of the law, and that the petitioners have no locus standi since they do not claim to be in imminent danger of being prosecuted under the law. Can the court proceed to decide the case even if the law has not yet become effective? A. The Supreme Court can proceed to decide the case even if the law has not yet become effective, since the petition filed sought to nullify the Cybercrime Prevention Act because it violated several provisions of the Bill of Rights. The Supreme Court became duty-bound to settle the dispute. Since it is alleged that the Cybercrime Prevention Act violates various provisions of the Bill of Rights, including freedom of speech, freedom of the press, and the right against unreasonable searches and seizures, the issues raised are of paramount public interest, of transcendental importance, and with far-reaching constitutional implications that justify dispensation with locus standi and exercise of the power of judicial review by the Supreme Court. Chavez versus Gonzalez. Jurisprudence provides that locus standi is not required when the action was filed to prevent a chilling effect on the exercise of the right to freedom of expression and overbreadth. Q. What is the concept of expanded judicial review under the 1987 Constitution? A. The concept of expanded judicial review of the Supreme Court, the facial challenge to the constitutionality law, is no longer limited to laws which violate the freedom of speech, but applies to all violations of fundamental rights under the Bill of Rights. In addition, the remedies of certiorari and prohibition in the Supreme Court are broader in scope and may be issued to correct errors of jurisdiction of judicial, quasi-judicial, or ministerial actions and may be invoked to restrain any act of grave abuse of discretion of any branch of government. Define doctrine of or operative facts. The doctrine of operative facts means that before a law was declared unconstitutional, its actual existence must be taken into account, and whatever was done while the law was in operation should be recognized as valid. Q. Judicial power, as defined in Section 1, second paragraph of Article 8, 1987 Constitution, now include the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. This definition is said to have expanded the power of the judiciary to include political questions formerly beyond its jurisdiction. Do you agree with such an interpretation of the constitutional definition of judicial power that would authorize the courts to review and, if warranted, reverse the exercise of discretion by the political departments, executive and legislative, of the government, including the Constitutional Commission? Discuss fully. In your opinion, how should such definition be construed so as not to erode considerably of disregard entirely the existing political question doctrine? Discuss why. Discuss fully. Answer. To letter A, yes, the second paragraph of Section 1, Article 8 of the 1987 Constitution has expanded the power of the judiciary to include political questions. This was not found in 1937 and the 1973 Constitution. Precisely, the framers of the 1987 Constitution intended to widen the scope of judicial review. Letter B, as pointed out in Marcos versus Manglapos, 177 Squa 668, so as not to disregard entirely the political question doctrine, the extent of judicial review when political questions are involved should be limited to a determination of law of whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the official whose act is being questioned. If grave abuse of discretion is not shown, the court should not substitute their question for that of the official concerned and decide a matter which by its nature or by law is for the latter alone to decide. Q. To what extent, if at all, has the 1987 Constitution affected the political question doctrine? A. Section 1, Article 8 of the Constitution has expanded the scope of judicial power by including the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. In Marcos versus Manglapos, the Supreme Court stated that because of this, courts of justice may decide political questions if there was grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the official whose action is being questioned. Q. The 1935, 1973, and 1987 constitutions commonly provide that judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. What is the effect of the addition in the 1987 Constitution of the following provision? Judicial power includes the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Discuss briefly, citing at least one illustrative case. A. The effect of the second paragraph of Section 1, Article 8 of the 1987 Constitution is to limit resort to the political question doctrine and to broaden the scope of judicial inquiry into areas which the judiciary under the previous constitutions would have left to the political departments. If a political question is involved, the judiciary can determine whether or not the official whose action is being questioned acted with grave abuse of discretion amounting to lack or excess of jurisdiction. Marcos versus Manglapos. Thus, although the House of Representatives Electoral Tribunal has exclusive jurisdiction to decide election contests involving members of the House of Representatives, the Supreme Court nullified the removal of one of its members for voting in favor of the protestant who belonged to a different party, Bondoc versus Pineda. Q. Name at least 3 constitutional safeguards to maintain judicial independence. Answer. The following are the constitutional safeguards to maintain judicial independence. Number 1. The Supreme Court is a constitutional body and cannot be abolished by mere legislation. Number 2. The members of the Supreme Court cannot be removed except by impeachment. Number 3. The Supreme Court cannot be deprived of its minimum jurisdiction prescribed in Section 5, Article 10 of the Constitution. Number 4. The appellate jurisdiction of the Supreme Court cannot be increased by law without its advice and concurrence. Number 5. Appointees to the judiciary are nominated by the judicial and Bar Council and are not subject to confirmation by the Commission on Appointments. 6. The Supreme Court has administrative supervision over all lower courts and their personnel. 7. The Supreme Court has exclusive power to discipline judges of lower courts. 8. The members of the judiciary have security of tenure, which cannot be undermined by a law or reorganizing the judiciary. 9. Members of the judiciary cannot be designated to any agency performing quasi-judicial or administrative functions. 10. The salaries of members of the judiciary cannot be decreased during their continuance in office. 11. The judiciary has fiscal autonomy. 12. The Supreme Court has exclusive power to promulgate rules of pleading, practice, and procedure. 13. Only the Supreme Court can temporarily assign judges to other stations. 14. It is the Supreme Court who appoints all officials and employees of the judiciary. Cruz, Philippine Political Law, 1995. Q. The Judicial and Bar Council is composed of the following. A. The Chief Justice as ex officio chairman. B. Secretary of Justice as ex officio member. C. A representative of Congress as ex officio member. D. A representative of the Integrated Bar. E. A professor of law. F. A retired justice of the Supreme Court. G. A representative of the private sector. The term of office of the regular members is 4 years. Q. Enumerate the cases required by the Constitution to be heard en banc by the Supreme Court. A. The following are the cases required by the Constitution to be heard en banc by the Supreme Court. 1. Cases involving the constitutionality of a treaty, international or executive agreement, or law. 2. Cases which under the rules of courts are required to be heard en banc. 3. Cases involving the constitutionality, application, or operation of presidential decrees, proclamation orders, instructions, ordinances, and other regulations. 4. Cases heard by a division when the required majority is not obtained. 5. Cases where a doctrine or principle of law previously laid down will be modified or reversed. 6. Administrative cases against judges when the penalty is dismissal. 7. Election contest for president or vice president. Q. The court had adopted the practice of announcing its decision in important controversial or interesting cases the moment the votes had been taken among the justices, even if the final printed decision and separate opinions are not yet available to the public. In a greatly anticipated decision in a case of wide-ranging ramifications, the voting was close, 8 for the majority, while 7 were for the other side. After the court had thus voted, it issued a press release announcing the result, with the advice that the printed copy of the decision together with the separate opinions were to be issued subsequently. The following day, however, one of the members of the court died. The court then announced that it would deliberate anew on the case, since apparently the one who died belonged to the majority. Citizens of Transparency, a group of civic-spirited professionals and ordinary citizens dedicated to transparency and accountability in the government, questioned the act of the court. The petitioners claimed the decision had already been validly adopted and promulgated. Therefore, it could no longer be recalled by the court. At the same time, the group also asked the court to disclose to the public the original decision and the separate opinions of the magistrates, together with what they had deliberated on just before they came up with a press release about the 8-7 decision. Was the announced 8-7 decision already validly promulgated and thus not subject to recall? Answer. The decision cannot be deemed to have been promulgated simply because of the announcement of the voting in a press release, because the decision has not yet been issued and filed with the clerk of court. Until the decision is filed with the clerk of court, the justices still have control over the decision and they can still change their votes. If the decision was not yet finalized at the time when the justice died, could it still be promulgated? The decision can no longer be promulgated if the justice who belonged to the majority died. For lack of majority vote, the vote he cast is no longer valid, as he was no longer an incumbent member of the Supreme Court. If the decision was still being finalized Should the court release to the public the majority decision and the separate opinions as originally announced together with their deliberations on the issue? The Supreme Court should not release to the public the majority opinion and the separate opinions as well as its deliberations. They are part of its confidential internal deliberation. Q. Congress enacted a law providing for trial by jury for those charged with crimes or offenses punishable by reclusion perpetua or life imprisonment. The law provides for the qualifications of members of the jury, the guidelines for the bar and bench for their selection, the manner a trial by jury shall operate, and the procedures to be followed. Is the law constitutional? Answer. The law providing for trial by jury is unconstitutional because of the omission in Article 8, Section 5, Number 5 of the 1987 Constitution and Article 10, Section 5 of 1973 Constitution, which authorizes the legislature to repeal, alter, or supplement the rules of procedure promulgated by the Supreme Court. Congress can no longer enact a law governing rules of procedure for the courts. Echegaray v. versus Secretary of Justice. Question: true or false? A law fixing the passing grade in the bar examinations at 70% with no grade lower than 40 in any subject is constitutional. Answer: false. Such a law entails amendment of the rules of court promulgated by the Supreme Court. The present Constitution has taken away the power of Congress to alter the rules of court. The law will violate the principle of separation of powers. Alternative answer: true. Deliberations in the CONCON reveal that Congress retains the power to amend or alter the rules because the power to promulgate rules is essentially legislative, even though the power has been deleted in the 1987 Constitution. If the law, however, is retroactive, it is unconstitutional because it is prejudicial. Q. Congress enacted a law exempting certain government institutions providing social services from the payment of court fees. Attorney Christopher Timoteo challenged the constitutionality of the said law on the ground that only the Supreme Court has the power to fix and exempt said entities from the payment of court fees. Congress, on the other hand, argues that the law is constitutional as it has the power to enact said law, for it was through legislative fiat that Judiciary Development Fund and the special allowance, the funding of which are sourced from the fees collected by the courts, were created. Thus, Congress further argues that if it can enact a law utilizing court fees to fund the JDF and SAJJ, a fortiori it can enact a law exempting the payment of court fees. Discuss the constitutionality of the said law, taking into account the argument of both parties. Answer: the law is constitutional. The Constitution has taken away the power of Congress to repeal, alter, or supplement the rules of court. The fiscal autonomy guaranteed the judiciary by Section 3, Article 8 of the Constitution recognized the authority of the Supreme Court to levy, assess, and collect fees. Congress cannot amend the rules promulgated by the Supreme Court for the payment of legal fees by granting exemptions. Question: Congress passed a law, RA number 15005, creating an administrative board principally tasked with the supervision and regulation of legal education. The board was attached to the Department of Education. It was empowered, among others, to prescribe minimum standards for law admission and minimum qualifications of faculty members. The basic curricula for the course of study aligned to the requirements for admission to the bar, law practice and social consciousness, as well as to establish a law practice internship as a requirement for taking the bar, which a law student shall undergo any time during the law course, and to adopt a system of continuing legal education. Professor Bombastic, a longtime law practitioner and lecturer in several prestigious law schools, assailed the constitutionality of the law, arguing that it encroached on the prerogatives of the Supreme Court to promulgate rules relative to admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. If you were Professor Bombastic's understudy, how may you help him develop clear, concise, and cogent arguments in support of his position based on the present Constitution and the decision of the Supreme Court on judicial independence and fiscal autonomy. Answer: the statutory authority granted to the Administrative Board to promulgate rules and regulations cannot encroach upon the exclusive authority of the Supreme Court to regulate the admission to the practice of law. Section 5, Number 5, Article 8 of the Constitution. Thus, the Administrative Board cannot prescribe additional standards for admission to the practice of law, adopt a course study which is inconsistent with the requirements to take the bar examinations. Since Congress has no power to repeal, alter, or supplement the rules of court, it cannot delegate such power to the Administrative Board. Q. Under Section 5, Article 8 of the Constitution, the Supreme Court shall have the power to promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure of all courts. Section 23 of RA number 9165 of the Comprehensive Dangerous Drugs Act of 2002 provides that any person charged under any provision of this act, regardless of the imposable penalty, shall not be allowed to avail of the provision of plea bargaining. Patricio, a user who was charged with alleged sales of shabu, but who wants to enter into a plea of guilty to a charge of possession, questions the constitutionality of Section 23 on the ground that Congress encroached on the rule-making power of the Supreme Court under Section 5, Article 8. He argues that plea bargaining is procedural in nature and is within the exclusive constitutional power of the court. Is Patricio correct? A. Patricio is not correct. Defining the penalty of a criminal offense involves the exercise of legislative power. When Section 23 of the Comprehensive Dangerous Act prohibited plea bargaining, Congress defined what should be the penalty for the criminal offense. The power of the Supreme Court to promulgate rules of procedure is subject to the limitation that it should not modify substantive rights. Q. What is the meaning and guarantee of security of tenure? A. According to Palmera v. Civil Service Commission 235-87, security of tenure means that no office or employee in the civil service shall be suspended or dismissed except for causes as provided by law and after due process. Question. Ricardo was selected Dean of the College of Education in a state university for a term of 5 years, unless sooner terminated. Many were not pleased with his performance. To appease those critical of him, the President created a new position, that of Special Assistant to the President, with the rank of Dean, without reduction in salary, and appointed Ricardo to said position in the interest of the service. Contemporaneously, the University President appointed Santos as acting Dean in place of Ricardo. Does the phrase "unless sooner terminated" mean that the position of Ricardo is terminable at will? Was Ricardo removed from his position as Dean of College of Education or merely transferred to the position of Special Assistant to the President? Explain. Answer of letter A. No, the term "unless sooner terminated" could not mean that his position is terminable at will. Security of tenure means that dismissal should only be for a cause provided by law and not otherwise. Alternative answer: no, his position is not terminable at will. Ricardo's contract of employment has a fixed term of 5 years. It is not an appointment in an acting capacity or officer in charge. A college dean appointed with a term cannot be separated without cause. Ricardo, with a definite term of employment, may not thus be removed except for a cause. Letter B. Ricardo was removed from his position as dean, having as appointment with a fixed term. He cannot, without his consent, be transferred before the end of his term. He cannot be asked to give up his post, nor appointed as dean of another college, much less transferred to another position, even if it be dignified with a dean's rank. More than this, the transfer was a demotion, because deanship in a university, being an academic position which requires learning, ability, and scholarship, is more exalted than that of a special assistant who merely assists the president. As the title indicates, the special assistant does not make authoritative decisions, unlike the dean, who does so in his own name and responsibility. The position of dean is created by law, while the special assistant is not so provided by law. It was a creation of the university president. Q. Professor Masipag, who holds a plantilla or regular item in the University of the Philippines, UP, is appointed as an executive assistant in the Court of Appeals. CA. The professor is considered only on leave of absence in UP while he reports for work at the CA, which shall pay him the salary of the executive assistant. The appointment to the CA position was questioned, but Professor Masipag countered that he will not collect the salary for both positions, hence he cannot be accused of receiving double compensation. Is the argument of Professor valid? Explain. Answer. Although Professor Masipag is correct in saying that he cannot be accused of receiving double compensation as he would not actually be receiving additional or double compensation, it is submitted that he may nevertheless not be allowed to accept the position of executive assistant of the Court of Appeals during his incumbency as a regular employee of the University of the Philippines, as the former would be an incompatible office not allowed to be concurrent held by him under the provision of Article 9 B, Section 7 of the Constitution, the second paragraph of which specifies that unless otherwise allowed by law or by the primary function of his position, no appointive official shall hold any other office in the government. Q. Luz Biminda Marfal, joined by 11 other retrenched employees, filed a complaint with the Department of Labor and Employment, DOLE, for unpaid retrenchment or separation pay, underpayment of wages, and non-payment of emergency cost of living allowance. The complaint was filed against Food Terminal Incorporation, Food Terminal Inc. moved to dismiss on the ground of lack of jurisdiction, theorizing that it is a government-owned and controlled corporation and its employees are governed by the Civil Service Law and not by the Labor Code. Marfal opposed the motion to dismiss, contending that although Food Terminal Inc. is a corporation owned and controlled by the government, earlier created and organized under the General Corporation Law as the Greater Manila Food Terminal Incorporation, it has still the marks of a private corporation. It directly hires its employees without seeking approval from the Civil Service Commission, and its personnel are covered by the Social Security system and not the government service insurance system. The question posed in the petition for certiorari at bar whether or not a labor law claim against a government-owned or controlled corporation, like the Food Terminal Inc., falls within the jurisdiction of the Department of Labor and Employment or the Civil Service Commission. Decide and ratiocinate. Answer. The claim of the retrenched employees fall under the jurisdiction of the National Labor Relations Commission, NLRC, and not under the jurisdiction of the Civil Service Commission, as held in Lumanta versus National Labor Relations Office Commission. Since Food Terminal Inc. was organized under the corporation law and was not created by a special law in accordance with Section 2, Number 1, Article 9b of the Constitution, it is not covered by the civil service. Q. A corporation, a holder of a certificate of registration issued by the Securities and Exchange Commission, is owned and controlled by the Republic of the Philippines. The Civil Service Commission, CSC, is a memorandum order. In a memorandum order directs the corporation to comply with the civil service rules in the appointment of all its officers and employees. The memorandum order of the CSC is assailed by the corporation as well as by its officers and employees before the court. How should the case be resolved? Answer. The memorandum order of the Civil Service Commission should be declared void, as held in Gamogamo versus P. Noc. Shipping and Transit Corporation, under Article 9b, Section 2.1 of the 1987 Constitution. Government-owned or controlled corporations organized under the Corporation Code are not covered by the Civil Service Law, but by the Labor Code, because only government-owned and controlled corporations with original charters are covered by the Civil Service. Q. As counsel for the protestant, where will you file an election protest involving a contested election position in the barangay, municipality, C, the province, D, the city, E. The House of Representatives. Answer. In accordance with Section 2, Number 2, Article 9C of the Constitution, an election protest involving the elective position enumerated below should be filed in the following courts or tribunals. Letter A. Barangay, Metropolitan Trial Court, Municipal Circuit Trial Court, or Municipal Trial Court. B. Municipality, Regional Trial Court. C. Province, Comelec. D. City, Comelec. E. Under Section 17, Article 6 of the Constitution, an election protest involving the position of member of the House of Representatives shall be filed in the House of Representatives Electoral Tribunal. Q. In an election protest involving the position of governor of the province of Laguna between A. the protestee and B. the protestant, the First Division of the Commission on Elections rendered a decision upholding B's protest. Can A file a petition for certiorari with the Supreme Court under Rule 65 of the Rules of Court from the decision of the Comelec First Division? If yes, why? If not, what procedural step must he undertake first? Answer. A cannot file a petition for certiorari with the Supreme Court as held in Mastura v. Commission on Elections 285. The Supreme Court cannot review the decisions or resolutions of a division of the Commission on Elections. A should file first motion for reconsideration with the Commission on Elections and Bank. Q. The Department of National Defense entered into a contract with Raintree Corporation for the supply of ponchos to the armed forces of the Philippines, stipulating that in the event of breach, action may be filed in the proper courts in Manila. Suppose the AFP fails to pay for the ponchos. Where must Raintree Corporation file its claim? Why? Answer. Raintree Corporation must file its claim with the Commission on Audit under Section 2(1)(9)(d) of the Constitution. The Commission on Audit has the authority to settle all accounts pertaining to expenditure of public funds. Raintree Corporation cannot file a case in court. The Republic of the Philippines did not waive its immunity from suit when it entered into the contract with Raintree Corporation for the supply of ponchos for the use of the armed forces of the Philippines. The contract involves the defense of the Philippines and therefore relates to a sovereign function. In United States v. Ruiz, the Supreme Court held the restrictive application of state immunity is proper only when the proceedings arise out of commercial transaction of the foreign sovereign. Stated differently, a state may be said to have descended to the level of an individual and can thus be deemed to have tacitly given its consent to be sued only when it enters into business contracts. It does not apply where the contract relates to the exercise of its sovereign function. In this case, the projects are an integral part of the naval base, which is devoted to the defense of both the United States and the Philippines, indisputably a function of the government to the highest order. They are not utilized for nor dedicated to commercial or business purposes. The provision for venue in the contract does not constitute a waiver of the state immunity from suit, because the express waiver of this immunity can only be made by a statute. In Republic v. Purissima, the Supreme Court ruled apparently respondent judge was misled by the terms of the contract between the private respondent plaintiff in his sala and the defendant Rice and Corn Administration, which according to him anticipated the case of a breach of contract between the parties and the suits that may thereafter arise. The consent to be effective, though, must come from the state acting through a duly enacted statute, as pointed out by Justice Bengson in Mobile. Alternative answer. In accordance with the doctrine of exhaustion of administrative remedies, Raintree Corporation should first file a claim with the Commission on Audit. If the claim is denied, it should file a petition for certiorari with the Supreme Court. Q. The Philippine National Bank was then one of the leading government-owned banks, and it was under the audit jurisdiction of the Commission on Audit, COA. A few years ago, it was privatized. What is the effect, if any, of the privatization of PNB on the audit jurisdiction of the COA? Answer. In accordance with the ruling in Philippine Airlines v. COA, since the Philippine National Bank is no longer owned by the government, the Commission on Audit no longer has jurisdiction to audit it as an institution. Under Section 2, Number 2, Article 9(d) of the Constitution, It is government-owned or controlled corporations and their subsidiaries which are subject to audit by the Commission on Audit. However, in accordance with Section 2, Number 1, Article 9D of the Constitution, the Commission on Audit can audit the Philippine National Bank with respect to its accounts because the government still has an equity in it. Q. Towards the end of the year, the Commission on Audit (COA) sought the remainder of its appropriation from the Department of Budget and Management (DBM). However, the DBM refused because the COA had not yet submitted a report on the expenditure relative to the earlier amount released to it, and pursuant to no report no release policy of the DBM, COA is not entitled to any further releases in the meantime. COA counters that such a policy contravenes the guarantee of fiscal autonomy granted by the Constitution. Is COA entitled to receive the rest of its appropriations even without complying with the DBM policy? Answer: yes, COA is entitled to the rest of its appropriations even without complying with the DBM policy. That the no report no release policy may not be validly enforced against offices vested with fiscal autonomy is not disputed. Indeed, such policy cannot be enforced against offices possessing fiscal autonomy without violating Article 9, letter A, Section 5 of the Constitution, which provides Section 5, the Commission shall enjoy fiscal autonomy. Their approved appropriations shall be automatically and regularly released. Q. Distinguish civil rights from political rights and give an example of each right. Number 2. What are the relations of civil and political rights to human rights? Letter A. Civil rights refer to the rights secured by the Constitution of any state or country to all its inhabitants and not connected with the organization or administration of government. Political rights consist in the power to participate, directly or indirectly, in the management of the government. Civil rights define the relations of individuals amongst themselves, while political rights defines the relations of individuals vis-a-vis the state. Civil rights extend protection to all inhabitants of the state, while political rights protect merely its citizens. Examples of civil rights are the rights against involuntary servitude, religious freedom, the guarantee against unreasonable searches and seizures, liberty of abode, the prohibition against imprisonment for debts, the right to travel, equal protection, due process, the right to marry, right to return to his country, and right to education. Examples of political rights are the right to suffrage, the right of assembly, and the right to petition for redress of grievances. Human rights are broader in scope than civil and political rights, including social, economic, and cultural rights, and are inherent in person from the fact of their humanity. On the other hand, some civil and political rights are not natural rights. They exist because they are protected by a constitution or granted by law. For example, the liberty to enter into contract is not a human right but is a civil right. Q. Pedro bought a parcel of land from Smart Corporation, a realty firm engaged in developing and selling lots to the public. One of the restrictions in the deed of sale, which was annotated in the title, is that the lot shall be used by the buyer exclusively for residential purposes. A main highway having been constructed across the subdivision, the area became commercial in nature. The municipality later passed a zoning ordinance declaring the area as a commercial bank building on its lot. Smart Corporation went to court to stop the construction as violative of the building restrictions imposed by it. The corporation contends that the zoning ordinance cannot nullify the contractual obligation assumed by the buyer. Decide case. Answer: the case must be dismissed as held in Ortigas and Company Limited Partnership versus FEATI Bank and Trust Company 94-533. Such a restriction in the contract cannot prevail over the zoning ordinance because the enactment of the ordinance is a valid exercise of police power. It is hazardous to help and comfort to use the lot for residential purposes since a highway crosses a subdivision and the area has become commercial. Q. In the deed of sale to and in the land titles of homeowners of a residential subdivision in Pasig City, there are restrictions annotated therein to the effect that only residential houses or structures may be built or constructed on the lots. However, the City Council of Pasig enacted an ordinance amending the existing zoning ordinance by changing the zone classification in that place from purely residential to commercial. A lot owner sold his lot to a banking firm, and the latter started constructing a commercial building on the lot to house a bank inside the subdivision. The subdivision owner and the homeowners association filed a case in court to stop the construction of the building for banking business purposes and to respect the restrictions embodied in the deed of sale by the subdivision developer to the lot owners, as well as the annotation in the titles. If you were the judge, how would you resolve the case? Answer: If I were the judge, I would dismiss the case as held in Ortigas and Company Limited Partnership versus FEATI, Bank and Trust Company, 94 633. The zoning ordinance is a valid exercise of police power and prevails over the contractual stipulation restricting the use of the lot to residential purposes. Q. As a reaction to the rise, shortage, and the dearth of mining engineers, Congress passed a law requiring graduates of public science school henceforth to take up agriculture or mining engineering as their college course. Several students protested, invoking their freedom to choose their profession. Is the law constitutional? Yes, the law is constitutional. It is a valid exercise of the state's police power. Police power concerns government enactments which precisely interfere with personal liberty or property in order to promote the general welfare or the common good, and that the means employed are reasonably necessary for the accomplishment of the purpose and not unduly oppressive upon individuals. It cannot be denied that a rice shortage and a dearth of mining engineers are valid concerns that affect the common good and must be addressed by the state. Since the law is limited to public science high school, it is within the police power of the state to require the graduates whose education it has subsidized to take up agriculture or mining engineering. The law provides for a lawful method geared toward a lawful objective, and as such may be considered to be a reasonable exercise of the state's police power. Q. The National Building Code and its implementing rules provide, inter alia, that operators of shopping centers and malls should provide parking and loading spaces in accordance with the prescribed ratio. The Solicitor General, heeding the call of the public for the provision of free parking spaces in malls, filed a case to compel said business concerns to discontinue their practice of collecting parking fees. The mall owners and operators oppose, saying that this is an invalid taking of their property, thus a violation of due process. The Solicitor General justifies it, however, claiming that it is a valid exercise of police power. Could the mall owners and operators be validly compelled to provide free parking to their customers? Answer: No. The mall owners and operators cannot be validly compelled to provide free parking to their customers because requiring them to provide free parking space to their customers is beyond the scope of police power. It unreasonably restricts the right to use property for business purposes and amounts to confiscation of property. Office of the Solicitor General versus Ayala Land, 600 SCRA 617. Q. The City of San Rafael passed an ordinance authorizing the city mayor, assisted by the police, to remove all advertising signs displayed or exposed to public view in the main city street for being offensive to sight or otherwise a nuisance. AM, whose advertising agency owns and rents out many of the billboards ordered removed by the city mayor, claims that the city should pay for the destroyed billboards at their current market value since the city has appropriated them for the public purpose of city beautification. The mayor refuses to pay, so AM is suing the city and the mayor for damages arising from the taking of his property without due process nor just compensation. Will AM prosper? Reason briefly. Answer: The suit of AM will not prosper. The removal of the billboards is not an exercise of the power of eminent domain, but of police power. Churchill versus Rafferty, 32 Phil 580. The abatement of a nuisance in the exercise of police power does not constitute taking of property and does not entitle the owner of the property involved to compensation. Association of Small Landowners in the Philippines versus Secretary of Agrarian Reforms. Alternative answer: the removal of the billboards for the purpose of beautification permanently deprived AM of the right to use his property and amounts to its taking. Consequently, he should be paid just compensation that is based on People versus Fajardo, 104 Phil 443. Q. Emilio had long suspected that Alvin, his employee, had been passing trade secrets to his competitor, Randy, but he had no proof. One day, Emilio broke open the desk of Alvin and discovered a letter wherein Randy thanked Alvin for having passed on to him vital trade secrets of Emilio. Enclosed in the letter was a check for 50,000, drawn against the account of Randy and payable to Alvin. Emilio then dismissed Alvin from his employment. Emilio's proof of Alvin's perfidy are the said letter and check, which are objected to as inadmissible for having been obtained through an illegal search. Alvin filed a suit assailing his dismissal. Rule on the admissibility of the letter and check. A. As held in People versus Marty, GR number 81561. Answer. As held in People versus Marty, GR number 81561. The Constitution, in laying down the principles of the government and fundamental liberties of the people, does not govern relationships between individuals. Thus, if the search is made at the behest or initiative of the proprietor of a private establishment for its own and private purposes and without the intervention of police authorities, the right against unreasonable search and seizure cannot be invoked, for only the act of private individuals, not the law enforcers, is involved. In sum, the protection against unreasonable searches and seizure cannot be extended to acts committed by private individuals so as to bring it within the ambit of alleged unlawful intrusion by the government. Accordingly, the letter and check are admissible in evidence. Waterist Drug Corp. versus NLRC. Alternative answer. The letter is inadmissible in evidence. The constitutional injunction declaring the privacy of communication and correspondence to be inviolable is no less applicable simply because it is the employer who is the party against whom the constitutional provision is to be enforced. The only exception to the prohibition in the Constitution is if there is a lawful order from the court or when public safety or order requires otherwise, as prescribed by law. Any violation of this provision renders the evidence obtained inadmissible for any purposes in any proceeding. Zulueta versus CA. Question. The Distilleria Felipe II is famous for its 15-year-old rum, which it has produced and marketed successfully for the past 70 years. Its latest commercial advertisement uses the line, "Nakatikim ka na ba ng 15 anyos?" Very soon, activist groups promoting women's and children's rights were up in arms against the advertisement. All advertising companies in the Philippines have formed an association, the Philippine Advertising Council, and have agreed to abide by all the ethical guidelines and decisions by the Council. In response to the protest, the Council orders the pull-out of the 15 Años advertising campaign. Can Distilleria Felipe II claim that its constitutional rights are thus infringed? Answer. Distilleria Felipe II cannot claim that its constitutional rights were infringed. In this case, a private association formed by advertising companies for self-regulation was the one who ordered that the advertisement be pulled out because Distilleria did not comply with the association's ethical guidelines. The guarantee of freedom of speech is a limitation of state action and not on the action of private parties. Lloyd Corporation versus Tanner, 407 U.S. 551. The mass media are private enterprises, and their refusal to accept any advertisement does not violate freedom of speech. Times Picayune Publishing Company versus United States. And Columbia Broadcasting System versus Democrat Control Committee. B. One of the militant groups, the Amazing Amazonas, call on all government-owned and controlled corporations, GOCC, to boycott any newspaper, radio, or TV station that carries the 15 Años advertisement. They call on all government nominees in sequestered corporation to block any advertising funds allocated for any such newspaper, radio, or TV station. Can the GOCCs and sequestered corporations validly comply? Answer. The government-owned and controlled corporations and the government nominees in sequestered corporation cannot block any advertising funds allocated for any newspaper, radio, or television station which carries the advertisement of the Distillera Philip II. Since they are government entities and officers, they are bound by the guarantee of freedom of speech. Freedom of speech extends to commercial advertisements. Metromedia, Inc. versus San Diego. The mere fact that an advertisement is offensive cannot justify its suppression. Kerry versus Population Services International. The blocking of advertising funds is a threat intended to prevent the exercise of the freedom of speech of Destillera Philip II through the fear of consequences. Such a threat qualifies as prior restraint. Rustin, The Law of Advertising, Volume 2, page 5 to 13.